Can a state prohibit the Nazi Party from marching in a town with a significant population of Holocaust survivors? To find out, you have to read National Socialist Party of America versus Village of Skokie. But it's 5 pages long. Don't have time for that? I've got you covered. This is TLDR, where I cover New York Court of Appeals cases in 5 minutes or less. But this is part of a special series I'm doing on landmark cases. Today we're focusing on a case that tested the bounds of the First Amendment, National Socialist Party of America versus Village of Skokie. The citation is 432 U.S. 43, and it was published by the United States Supreme Court on June 14, 1977. So let's dive into the details. To understand this case, we need to look at the First Amendment, which protects freedom of speech. The First Amendment of the United States Constitution is a cornerstone of American democracy. It states that Congress shall make no law abridging the freedom of speech. This broad protection covers a wide range of expression, from political discourse to artistic creations and beyond. Now, it's important to note that the First Amendment doesn't just protect speech we appreciate or find agreeable. It also shields distasteful, offensive, and even shocking speech. The idea is that in a truly free society, we must allow for a diversity of views, even those with which we vehemently disagree. This principle, known as viewpoint neutrality, asserts that the government cannot suppress speech simply because it disapproves of the message it carries. However, the protection of the First Amendment isn't absolute. There are limits, such as incitement to violence, defamation, and obscenity. Balancing these exceptions against the importance of free speech can make for some complex legal questions. Now that we have a grasp on the law, let's look at the facts of this case. The facts of this case are quite interesting. Here we have the National Socialist Party of America, a group known for espousing anti-Semitic views many find abhorrent, planning to march through the village of Skokie, Illinois. Skokie was not a random choice. Up to 10% of the residents were Holocaust survivors, and more than half of the residents were Jewish, making this planned march particularly provocative and distressing to local residents. Now, the village of Skokie was not about to let this happen without a fight. They took legal actions to prevent the march from taking place, citing the potential for violence and the psychological trauma it would inflict on their large population of Holocaust survivors. The village filed for an injunction, a court order that would prevent the march from taking place. The village also passed laws prohibiting people from wearing military-style uniforms during demonstrations, as the Nazi demonstrators were planning to do. The village also passed a law prohibiting demonstrators from passing out hate speech pamphlets and requiring a bond. The National Socialist Party claimed that these acts by the village violated their First Amendment rights to free speech and assembly. This clash between the right to free speech and the desire to protect a vulnerable population from potential harm set the stage for a legal showdown. And these facts led to a legal battle that made its way to the United States Supreme Court. The procedural history of this case is quite straightforward. The National Socialist Party of America first sought a march permit from the village of Skokie. After being denied, they took their plight to the local courts, where they again faced rejection. Undeterred, they escalated their case to the Illinois Supreme Court, which upheld the lower court's injunction and refused to expedite the ruling on whether there was a First Amendment violation. Still not backing down, they pressed on to the United States Supreme Court. This brings us to the Supreme Court's holding. The Supreme Court made a significant decision in this case. The justices, in a profound interpretation of the First Amendment, held that the state cannot impose an injunction like this unless it provides strict procedural safeguards and immediate appellate review. Furthermore, the court held that if the state does not provide immediate appellate review, it must allow a stay of the injunction, then permitting the march to take place. The implication of this holding is that the First Amendment protects even the most offensive and reprehensible speech. When the case ultimately went back to the Illinois Supreme Court, they held that the swastika is a symbolic form of free speech entitled to First Amendment protections and does not, by itself, constitute fighting words. The National Socialists were allowed to march. This decision had a profound impact. The impact of National Socialist Party of America versus Village of Skokie is still felt today. This landmark case set a precedent that continues to shape our understanding of the First Amendment, even in the face of speech that many find deeply offensive. It underscored the principle that the right to free speech is not viewpoint selective. It doesn't cater to popular sentiment. In essence, it pushed us to grapple with the uncomfortable reality that the freedom of speech also extends to views we vehemently disagree with. It has influenced countless subsequent cases, reinforcing the notion that our Constitution protects all voices, not just the ones we want to hear. This case reminds us that even speech we find deeply offensive is protected under our Constitution. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.